Adhiambo a sum of 961,771 by false pretending that you were in a position to assist or import a vehicle to RAV4 from the United Kingdom. Second count relates to the offense of obtaining money by false pretenses. Contrary section 313 of the Penal Code. Particulars: on the 8th of October 2019 at the Family Bank of KTDA, Moi Avenue branch in Nairobi, within Nairobi County, joined with others not before court with intent to defraud Sh900k Adhiambo a sum of 961,771 by false pretending that you are in a position to assist or import a motor vehicle Toyota RAV4 from the United Kingdom, a fact you knew to be false. The alternative count is Bora Mwangi, where Rumo is charged with the offense of handling stolen goods, contrary section 32212 of the Penal Code. The particulars are: on or before 8 October 2019 at Family Bank, KTDA Moi Avenue branch in Nairobi, within Nairobi County, in the course of stealing, dishonestly received a sum of 961,771 in your account ending with 830, held at Family Bank Limited, and the property of Sh900k Adhiambo, knowing or having reasons to believe it to be stolen. I also heard what the witnesses said, both the defense and together with the prosecution witnesses. Now, in respect to conspiracy to commit a crime and obtaining money by false pretense, I have this to say. The accused persons are charged with the offense of conspiracy to commit a crime under section 9.3. The section reads, any person who conspires with another to commit any felony or to do an act in part of the world, which if done in Kenya could be a felony, and which is an offense under the laws in force in the place where it is proposed to be done, is guilty of the offense of felony and is liable, if no other punishment is provided for, to imprisonment for 7 years. Or if the greatest punishment to which a person convicted of the felony is questioned is liable to less than imprisonment for 7 years, then to a lesser punishment. Equally in the second count, the accused persons have faced the offense of obtaining by false pretenses. I must say here that once the offense of conspiracy is established, the other counts will fall suit. Archibald in writing on criminal pleadings at page number 2589 says that the offense of conspiracy cannot exist without the agreement, consent, or combination of two or more persons, so long as the design rests in the intention only. It's not indictable. There must be agreement. Proof of the existence of a conspiracy is generally a matter of inference deduced from the certain criminal acts of the parties accused, done in pursuance of an apparent criminal purpose in common between them. Madivo J, as it then was, in Moses Kabuye Karuoya versus the Republic 2016, together with the case of Bernard Chege versus Republic. The offense of conspiracy was discussed in detail, and the ingredients were defined in detail. These are inchoate crimes which are incomplete sometimes they are complete. So they must be connected to a substantive crime to obtain a conviction. Examples: some of the inchoate crimes are criminal conspiracy, criminal solicitation, and attempt to commit a crime when the crime has not been completed. So that, strictly speaking, inchoate crimes are a unique class of criminal offenses in the sense that they are criminalized acts that precede harmful conduct but do not necessarily inflict harmful consequences in and of themselves. It can thus be appreciated that it could extend to the criminal law too far to reach behind those acts and the criminalized behavior that proceeds from it. I think I need to go further than that. On closer scrutiny of the prosecution case, it is plain that the sum of monies at the center of this case was deposited to the account ending with 830 Family Bank KTDA branch Moy Avenue in the name of Outrigger General Stocks, and the signatory was Werimo Zipora. But more importantly, this account was given to the complainant by the accused person to make the payments into it. There was a narration by the first accused, David Ogola Omanya, that he had advised the complainant to use his company account, but she declined. However, in the re-examination, David Ogola Omanya concedes that indeed he advised the complainant to use either account to effect the deposit. To avoid bank charges, the complainant decided to use the account directly instead of using the accused's account, and then the same is transferred to the dealer. This is well captured in a re-examination at page 51 of the proceedings, where first accused David Ogola Omanya added the following to say, I quote, "There is a communication between me and the complainant over the payment of the car, and she wanted to know if she could pay to Outrigger or our company, and I told her to use either," end quote. There was also a testimony by the complainant which was not reported. She said that the first accused avoided her after the monies had been withdrawn from the account. This is evidence enough that the complainant did not commit an offense by using either account supplied to her by the first accused, David Ogola. Instead of the conduct of the first accused is telling after the withdrawal. Now, the basis of the Mombasa Miscellaneous Application 335-2019 was that the account had been hacked and the money stolen. Interestingly enough, no steps were taken to have Zebora Wairimu and others charged for this offense. This happened in 2019, and 6 years later, the culprits who handled the monies, including the second accused, has not been charged with theft. Instead, I see in the current case sheet, the second accused is charged with the offense of, or with the alternative count of handling stolen property, when in essence the account had allegedly hacked and the money stolen from the real. In respect of handling stolen property, the monies at the center of this case were traced to the account of ending 830 in the name of Outrigger General Stores, whose signatory was Bora Wairimu. This account was given to the complainant by the first accused person. Secondly, upon hitting the account, Spora withdrew the money, 970,000 shillings, via a check in the sum of 32,975.88 was utilized to offset a loan repayment in that account. There was an attempt by the second accused to discharge the evidentiary burden under Section 111 of the Evidence Act that the monies were withdrawn in favor of Josephat Nyamwanga, but there was no evidence to that effect. I dismiss that the explanation advanced by the second accused person. In this context, therefore, I refer to Lord Howard on circumstantial evidence, where he said, it has been said that the evidence against the applicant is circumstantial. So it is, but circumstantial evidence is very often the best. It is evidence of surrounding circumstances which, by undesigned coincidence, is capable of proving a proposition with the accuracy of mathematics. It is no derogation from evidence to say that it is circumstantial. Equally, in Abanga, Elias Onyango vs. Republic, some conditions were set down to rely on circumstantial evidence. The first one, the circumstances from which an inference of guilt is sought to be drawn must be cogently firmly established. Number two, those circumstances should be of a definite tendency, unerringly pointing towards the guilty of an accused person. Number three, the circumstance taken cumulatively should form a chain so complete that there is no escape from the conclusion that within all human probability, the crime was committed by the accused and none else. Now, taking into account the prosecution case and the defense case cumulatively, the offense is well captured that in Archibald writing on criminal pleadings at page 2589 and 2590, that the offense cannot exist without an agreement, consent, or a combination of two or more persons, so long as the design is intentional. However, the material on record is that the complainant did not know a trigger. It was given by David Ogolomanya via this invoice in question. And so the complainant deposited the monies into it. Shortly after sharing the deposit slip, David informs the complainant that the account has been hacked and money is withdrawn. What a coincidence. Has he ever used this account before, or is this the first time to use the account? This was the indirect consent bringing together the first and second accused persons. So the upshot is that the prosecution has proved this case against the accused persons in all the counts, and they convict each under section 215 of the CPC. Do you pass the records?
No records, Your Honor.
Mitigations have also taken into account the policy on sentencing. I think the first offenders are sentenced each to a fine of 200,000 shillings in default to serve 3 years imprisonment.
Most obliged, Your Honor.
I must oblige, Your Honor.